This video was brought to you by Medical Gear Outfitters. They are my go-to stop for all things medical. It doesn't matter whether you need something that just holds a bunch of Band-Aids and maybe some aspirin or something like that, or if you need an actual trauma kit. If you don't have a trauma kit in your house or in your vehicle, then I highly suggest that you go check our people out at Medical Gear Outfitters, and they offer all of you a discount. You can find all of that information over at the affiliates page and all the relevant places, and use that to great effect. RareBreed Triggers is back in the news yet again, folks, and today, double time, 2. Do you guys remember back when that whole settlement with the government thing happened, and I basically said, hey, all the folks that are doing anything associated with the super safety, you should probably be prepared to get popped by RareBreed Triggers, and they'll say the government made them do it or something like that. Yeah. So on Friday, they sued all the folks that are associated with super safety, and I'll have all those lawsuits listed on screen. We're not gonna have time to go through each of the individual lawsuits and the claims in them. We just don't have time to do that today. We got a lot of ground to cover. And then they also sued what looks to be a shell company associated with Spike's Tactical. And having read through that one actually looks like it's pretty valid. It looks like there was some like corporate finagling going on, like somebody basically tried to gain an equitable position within RareBreed. Defraud, okay? That one looks reasonable. The rest of them, I actually reached out to RareBreed for a statement on, and this is what they said. I've spoken directly with Tim Hoffman, and he admitted that the super safety infringes our patent. He just doesn't like the patent system. He claims that he was unaware of the patent at the time he released the super safety, but that doesn't change the fact that it infringes. This isn't the same patent RareBreed was enforcing in the past. It's a cam-driven design originally filed in 2003 under U.S. patent number 7398723. When the original inventor approached the ATF about it, they told him it was a machine gun. He had too much to lose at the time, so he chose not to bring it to market. In 2021, we purchased the rights to that patent. We then worked with the original inventor to develop a version that incorporated a 3-position safety and filed that new patent before Hoffman released his design. That new patent is U.S. patent number 120382447. They go on to say that claim 15 in the lawsuit covers the super safety, and it spells it out with a diagram. For effect, I'm going to be reading from this lawsuit. This is the one that is filed against D's Nuts Tactical. Claim 15, the 247 patent provides a novel device for accelerating the firing sequence of any semi-automatic firearm in contrast to a standard semi-automatic trigger or other prior art devices that allow accelerated rate of semi-automatic firing. The device can be selected to operate in either a standard semi-automatic mode or a forced reset semi-automatic mode, and uses a cam rotated by cycling of the action to force the trigger member to reset and prevent the trigger member from being pulled again until the action has returned to the in battery position. While the 247 patent may be adapted to many types of firearm, the 247 patent shows one embodiment design as drop-in replacement, particularly to fit AR-15 pattern firearms. The scope of the claimed invention, however, is defined by the claim of the 247 patent. And here are the diagrams that they are pointing out in that lawsuit. And they're also contained in the other lawsuits. That does not look like a self-contained device to me. Now, I am not a patent attorney, right? And I have no interest in being a patent attorney or the difference between this, that, or the other. Like it's very litigious to me. And while I appreciate that we have the ability to patent something and produce it for a period of time and not get it ripped off, even though, China's going to do it anyway, but, whatever. Again, I'm not a patent attorney. But as far as my understanding of the super safety, this is a thing that works with the rest of the stock trigger components. in your weapon. Now, I've never used one because I'm an SOT and I can get a machine gun. So I have never even considered this to be something that was on my radar to even try. I don't really understand forced reset triggers or the super safety anyway, except for a I'm not touching you. I'm not touching you. I don't see how a widget that people are 3D printing, among other things, that interacts with the stock components of your firearm, your stock trigger components. I don't see how that thing infringes on the patent of a self-contained device that does a similar thing. It's called convergent evolution, right? And they're just coming at it from two different directions. I don't see how those two things can be called the same thing. But again, I'm not a patent attorney. All I know is it feels gross. Let me know what you think about that. Do you feel gross about that? Should they be doing that sort of stuff? And then that brings us back to the whole thing about the settlement with the government. And I haven't seen them do this yet, claim that they had to do it because the government said to, because that's not what the settlement says. If we go back to the settlement, it says this: RBT, RBF, Mr. DeMonico, and Mr. Maxwell agree to take all reasonable efforts to engage in patent enforcement, seeking prohibitory injunctions against any person or entity that manufactures, sells, or distributes any FRT during the life of the U.S. Patent 223, provided RBT, DeMonico, and Maxwell have a good faith argument that the device is within the scope of the patent. So to wrap it up and put a bow on it, the government says that they have to enforce the 223 patent, not the 247 patent. So they're choosing to enforce this patent. And I think what makes that feel gross is that this is very First Amendment, Second Amendment. Like, we're doing this because it follows the letter of the law, whether that was the intent of Congress or not, doesn't matter, is not a machine gun. And because it's not a machine gun, we're going to do it, and that is the whole purpose. So basically, RareBreed is interdicting people's ability to exercise those rights for the sake of quashing competition for its device. Ugh. I find it entirely plausible as to why they're having problems with a money guy in one of their other lawsuits. Remember that I said that RareBreed is in the news twice today? Well, that all happened on Friday, and what goes around comes around, because RareBreed got sued by like 10 states, and here's what it looks like. United States District Court for the District of Maryland. Talk about venue shopping. Yikes. State of New Jersey, State of Maryland, State of Delaware, State of Colorado, District of Columbia, State of Hawaii, State of Illinois, State of Maine, Massachusetts, people of the state of, sorry, I thought that was like the People's Republic there for a second. Michigan, Minnesota, Nevada, Oregon, Rhode Island, Vermont, and Washington. And it's all the gun violence epidemic stuff that you expect it to be, right? And they're not happy about the fact that the federal government settled this, basically. So they're going to go after RareBreed. Now, you can read this whole thing yourself, but the prayer for relief is as follows. A, declare that the redistribution policy is ultra vires, which means outside of its statutory authority. Declare that the redistribution policy is agency action that is contrary to the laws of the United States and therefore unlawful statute. Preliminary and permanently enjoin the government defendants from implementing or enforcing the redistribution policy beyond that specifically required by another judicial order by returning any FRTs to any individuals or entity located in the plaintiff states or to any distributor, dealer, seller, or other entity that sells, resells, or otherwise redistributes FRTs into plaintiff states, either directly or indirectly, vacate and set aside the redistribution policy pursuant to that statute, award states their fees and costs, and whatever this court may deem necessary and proper. I don't particularly believe in karma, but I think it fits. Karma's a bitch. I don't like it when the government is involved with a lawsuit against a Second Amendment organization, but I also don't like it when Second Amendment organizations sue each other. So I don't know. What do you guys think? I'm out of here. It's late.